Morning, everyone. Welcome to today's Drugs Don't Work in New Jersey webinar. I just wanted to come on for a minute before I turn you over to our expert panelists and guest moderator to welcome you and to acknowledge that this is the 25th anniversary of the Drugs Don't Work in New Jersey program. And so wanted to extend a special welcome to all of our members and provide an extra special welcome to those of you who aren't members who are just joining us as well. And we hope that you will partake in the resources that are available through Drugs Don't Work in New Jersey, including webinars like this and weekly and bi-weekly updates on different topics that impact small businesses, nonprofits, and other organizations throughout the state. As I said, we have an expert panel. You're in great hands with some incredible information, incredible resources that our expert panelists are going to be providing us. But without any further, I will turn it over to our moderator for today, Burt Barron. Burt is known throughout New Jersey as the morning host of WRNJ's morning program and the Be Inspired podcast. And Burt is a great friend to the partnership. He has moderated many of our events, and we appreciate him being with us today. And like I said, going to turn it over to you, Burt. Thanks again, everyone, for joining us, and enjoy the webinar.
Angela, thank you very much, and good morning to you, and good morning, everyone. And as Angela mentioned, this is the 25th annual webinar for the members of Drugs Don't Work in New Jersey, the partnership's free, drug-free workplace program. So we welcome the current members of the program. We also extend a special welcome to employers in New Jersey who are joining us for the very first time. Just a few housekeeping details before we get started. The slide presentation, as well as a recording of the webinar, will be sent to all participants. Now, some of you submitted questions in your registration, and those of you who have questions will be able to put them into the chat feature. We try to answer as many questions as we can after the attorneys have completed their slide presentation. We know, partly as a result of the mental health issues that so many people are struggling with, that the misuse and abuse of alcohol and other drugs and drug use has increased over the past few years. Additionally, there are now over 100 dispensaries open for business in New Jersey, selling cannabis in various forms. We cannot ignore the possibility of our employees coming to work impaired. How do supervisors go about dealing with the potential impairment of an employee on the job, especially if they're on the road or perhaps involved in other safety-sensitive work? The different types of marijuana available for sale, their different levels of potencies, and how marijuana affects each individual differently all make this issue an ongoing challenge for New Jersey employers. So we want to help you as much as possible to deal with that situation, as well as bring you up to date on other issues related to maintaining a healthy, safe, and drug-free workplace. So let's bring in our expert speakers for today. We will first have an update on legal and legislative developments, both on the national and state level. Nancy N. DeLogue, well known to members of our drug-free workplace program. She has presented for the partnership for a number of years. Nancy is a shareholder of Littler Mendelsohn PC, nationally recognized authority on federal and state drug-free workplace and drug testing issues, and has spent much of her career focusing on workplace drug policies and procedures, including programs that are mandated by the Department of Transportation. Working with Nancy today is Lauren Marcus. Lauren is also a shareholder at Littler Mendelsohn and works out of their Newark office. She represents and advises employers in various aspects of employment law, and regularly advises and counsels clients on a wide array of day-to-day concerns, including leaves of absence issues, wage and hour questions, and handbooks and policies. Also with us is another attorney from Littler Mendelsohn, Demetrios T. Marcos. Demetrios is an experienced employment litigator with a particular expertise in litigating discrimination and wage and hour disputes, including cases in both federal and state courts. He also works with human resource professionals on various aspects of the employment relationship, including hiring practices, handbook policies, employee discipline, termination decisions, as well as severance agreements. We are so grateful to have these three attorneys ready and willing to provide this update. So now we'll turn things over to Nancy DeLogue. Good morning.
Good morning. Thank you, Bert. That's a really kind invitation. And I have to, it's 25 years in 2025. This is amazing. And you were very um, polite. You said, well, she's been with us a number of years. It's true. I feel like I may have been here since the beginning or nearly the beginning. So it's really great that this organization is still doing the good work that they are doing. For those of you who haven't been to one of these presentations before and haven't seen my colleagues, Lauren, who has presented with me before, and Demetrios, who is new to us, I was raised in Connecticut. You should not. I mean, you're in New Jersey. This is don't take it from me. Yes, I may be a national expert, whatever, but I wanted to bring my colleagues who are here in Newark and on the ground who actually see what's happening in New Jersey. And we are lawyers that you call about drug issues. So we have a really fun practice and we see a lot. So if we can answer some of your questions today, we're happy to do so. And we really enjoy it, right? We know employers have challenges providing, recovery friendly workplaces, drug free workplaces, drug testing, the whole gamut. And if we can be helpful to anybody really in making their workplace a better place for the employees or the employers, we're grateful to do that. So, you know, I think it's both wonderful and sad that we're here 25 years later, but we are doing more and different things, and the issues have evolved, and so that's very exciting. As is typical, right? We'll do an overview really of the evolving law on drug use, and you heard some allusions to that about all the different varieties of marijuana, for example, that are available in the U.S. Or in New Jersey in particular. But what is the policy? Where does that look like it's going right now? And then more the pressing question. I don't know that we can answer all the things you can do versus things you can't do, but we try to give you a solid overview of what employers can expect and require. And just to give you a real life flavor of stuff that we're seeing other employers deal with, what's it like on the ground? Um, how do you deal with impairment and performance issues? These are two totally different things sometimes. And so somebody might be impaired, but their work seems to be good, or you don't want to lose that employee. Is there a different way that you can approach that than with somebody whose performance is poor and maybe there's also a drug issue going on? The question du jour, right? Can we test for marijuana? Why would we test for marijuana? Why, what can we do if we test for marijuana? What can we do with the results? And then, sort of an overview. We're not going to tell you to change your policy and procedures. This organization does a great job with its model policies, but sometimes I find that employers haven't looked at it for a while. We like to set and forget our policies, and they're not working for us as well as they used to be. Maybe because the law has changed. Maybe because the issues that are cropping up in your workplace are different. So we try to cover what we're seeing there as well. So without, just the overview of New Jersey drug-free workplace law, we're going to talk about cannabis and marijuana a lot because you are one of the states that is most permissive, if you will, on the use of marijuana. And also you do have workplace protections for people who engage in marijuana use away from work. But your law is called the cannabis law, right? And so, you may have seen this if we've been on here before, but what is cannabis and what is unlawful and what are you allowed to regulate? I'll start by saying cannabis is anything right from the cannabis plant. There's actually debate as to whether there's hemp versus cannabis sativa. Are they the same plant? Are they two different, genres of plant? I'm not an expert on that. But we wanted to be clear that cannabis generally is a catch-all phrase, but marijuana is what's illegal as a matter of federal law. And marijuana differs from cannabis generally in that the feds have defined it to include something that has tetrahydrocannabinoid or cannabinol in excess of 1/3 of 1%, right? So hemp products that don't have THC in them are legal as a matter of federal law. We as employers are really concerned, if you will, about the potential for impairment, the potential for people to be um, high at work, for making poor decisions, and that will be because of their use of a cannabis product that includes THC. So our employer drug tests all look for the presence of THC in a test sample. And we'll get into this a little bit more later. Some tests look for metabolites of THC, something that you have metabolized. It's no longer in your system, but that is going to be perhaps detectable even after use. There are also tests that detect active THC in someone's system, and those are really interesting, right, for employers that are trying to focus on not whether you use marijuana away from work, but whether you may be impaired on the job. So we're going to talk about that. But all of the tests that we'll talk about test for marijuana, not cannabis, not CBD. If someone's using a CBD product that does not have this cannabis in it at the level made unlawful by federal law, they will not test positive on your drug test because you're not looking for cannabinoids. So we'll come back to that. But that's why we talk about marijuana use, to distinguish it from other products that may not include THC. And it's like a little bit of a primer because we will kind of go back and forth. You're not going to know whether a particular product, a hand cream, something like that, has CBD in it or THC in it, or either or both. And the reason you're not going to know that is that although there are rules, there are no regulations or regulators that enforce those rules because they're considered to be supplements. So federal law doesn't actually test those. And so if somebody puts out a CBD product that contains THC, that may be deliberate, certainly legal in New Jersey. But if it says it doesn't include THC and it's wrong, then the only avenue the individual has is to try and go after the manufacturer. So employers just say, no cannabis products with if whatever you're using causes you to test positive, we have a problem with that. There's a long introduction on cannabis versus marijuana, but hopefully helpful to set the stage. So what does the law about marijuana use by workers say in New Jersey? Demetrios, Lauren, do you want to jump in? You guys are here on the ground in New Jersey. What does it say?
So the general background, for those of you who haven't been with us before, is marijuana is recreationally legal, but you cannot take any action against an employee because of their lawful off-duty use of it. So basically, a lot of states, not a lot, but when states started legalizing recreational marijuana, it didn't actually go to the point of protecting employees. New Jersey was one of the first, if not the first state to really go there. California now is as well, but we say not only is it legal, but using marijuana is a protected activity for employees. So you cannot take adverse action against an employee solely because of their off-duty use of marijuana. So that's a lot of what we'll be discussing today is the question of, and I saw one of the questions already posted, which we will get to shortly in our presentation, is about, okay, so we understand you're allowed to use marijuana not at work. We can still tell people they cannot use marijuana at work. How do we get from A to B? What can we do about this? But it's a very, very broad protection that employees in New Jersey have.
And I just put up the slide about that.
Perfect.
The general one. But obviously we haven't reproduced the law in total here.
Right. So this is the provision. It says you cannot refuse to hire any person or discharge or take any adverse action against an employee. So you can't change their wages, terms and conditions of employment because they do or do not use marijuana. It says cannabis products. We just went through this, but
Yeah.
but that's the main. This is the provision of the law that we'll be discussing. This is the big thing that really impacts employers in New Jersey.
And what is the scope of that, right? Maybe this is the other question we get asked most often about cannabinoid metabolites in the employee's bodily fluid. What is that?
So this goes back to also what Nancy alluded to. So you can't take any adverse action against someone solely because of the presence of cannabinoid metabolites in their bodily fluid. So basically what this gets to is if employees are now protected, if they engage in the use of marijuana, not during working time, off duty, some of the tests that we do. So as Nancy said before, you test for either THC metabolites or the actual drug. If you test for the metabolites, all that shows it's that someone previously used marijuana, that their body already processed marijuana, and the metabolites are evidence of that. So when marijuana was unlawful, it was a great test because you test it, you show that someone did unlawful drugs, you could take adverse action about it. Now, if someone uses marijuana, if someone tests positive for marijuana and you're using a test that tests for metabolites, then they can just say, yeah, it's because I smoked over the weekend. I'm not smoking now. And so based solely on that test, you're not allowed to take any action against an employee. So as we'll discuss, you have to start relying on other factors and trying to, actually be able to determine whether they are impaired or under the influence at work.
What do you think? And I'm going to talk about this a little bit later, but this particular section of the statute, the inverse of what it says is you can't take action solely due to the presence of cannabinoid metabolites, right? So if you can show that they're impaired and that's in their system or in their sample, then maybe you can act. But the opposite of this is an employee shall not be, can an employer take adverse action based exclusively on a test that shows not cannabis metabolites, but active THC in the individual's system. And if you don't know right now whether your drug tests are measuring active THC or not, I can tell you if you're doing a urine drug test, you're testing for cannabis metabolites. And so that urine drug test is not very helpful to you. But if you're doing an oral fluid test, and I hope nobody here is doing blood tests, but sometimes healthcare hospitals have the access to that information, then you may be measuring, and you probably should confirm you are measuring for active THC in the individual system. It can only be in their system for a few hours after they've used it. And so you have not a measure of impairment, but that there's active THC in their system at work. What do you think, Lauren, Demetrios? Would you still want to try and prove impairment under this statute, or would you be like, go for it? Oral fluid test is positive. Or would you say, call your lawyer and let's talk through the facts?
That would be my suggestion. Call your lawyer to talk through the facts. One of the things, and I know we're going to touch on this a little later, one of the things that the Act did do was establish someone called a workplace impairment recognition expert, a WIRE. It didn't actually give employers any guidance on what the protocol should be for WIRE recognition. But I think that a call with a lawyer is always going to be advisable in this situation, so that we can walk you through what should be done, the things you should look for, and then the next steps to determine whether impairment is present.
I also, my word of caution to most clients is always, so I do a lot of advice and counseling, not just on drug and alcohol use, but on a variety of employee issues. And generally, a lot of times when you have a question that's a one-off and it's oh, we got this test, the first question is, what do we normally do? What's our normal policy? So that's one of the reasons we say that you should talk it through with an attorney. Even if technically something might be lawful under this law, if you're applying it in a way that might be discriminatory or someone could argue is discriminatory, we want to make sure that we have the background information. So that's just something to keep in mind. And similarly, that brings me up to also the medical marijuana in New Jersey. So medical marijuana was lawful before recreational marijuana was. Employees were protected for using medical marijuana before they were for recreational marijuana. That law has not gone away. This law did not eliminate that. It didn't supersede that. That law is still there. So even though recreational marijuana is now legal and employees are protected for off-duty use of it, you have to keep in mind there technically is this other statute that seems somewhat unnecessary, but does have other requirements. And so you have to ensure that people are not medical marijuana users and go through that process. So that's just something to keep in your mind through all of this is there are other things in play, not just PREMA.
I think that's a great point. And, the ADA, the Americans with Disabilities Act, might come up even, if the person wasn't using medically, and you may have a union in place where you also need to do certain things to, before you take action. So we're talking exclusively about the law now. I'm going to move us along a little more quickly. And now we've sort of had this introduction and go a little bit more quickly through some of the details, and some of the questions that we're getting are in fact covered in our slides in our presentation here. So just to be clear, you can still drug test after this law. in accordance with New Jersey law generally, which is to say, Bill Lillis put in the chat that you should have a written policy. That's something that the Supreme Court of New Jersey recommended and said that it wants to see in 1992, right? So that's like it's out there, it's case law, you should have a written policy. This statute does talk about cannabis testing, and it says you can test for marijuana or pretty much at any time. The question is what you can do with the results. But if you and I get this question kind of a lot, if you are we don't test for marijuana most of the time because we don't want to know the information, but the vendor makes a mistake or they check the wrong form or somebody you haven't violated the law by asking for the test and getting the test done. You may be limited in what you can do with that information, but just on the back of your mind, good to know about that. This is sort of the takeaway for the if the drug test doesn't measure metabolites, you're going to be in a better position to act. All right, so now we have a new case, and we have a bunch of different information on what's new, but there's a new case out there, and this is something that I've alluded to a couple of times. Demetrios and Lauren put out an update about that, but an individual who believes they've been denied a job because of a positive drug test or state-permitted off-work marijuana use has no avenue to seek relief through the courts on that basis, setting aside the medical marijuana law. So what now? What's changing? And we're just going to sail through that and try and answer that question as we go through. So what's new? Which of you wants to take this, Demetrios or Lauren, or both of you?
Demetrios, he was excited about that.
I can take it. So back in early 2023, the plaintiff filed a lawsuit against a potential employer when he was denied a job based on a positive drug test. In May of 2023, the Third Circuit Court, the District of New Jersey Court, the federal court for all of New Jersey, decided that CREMA did not provide a right of action for individual plaintiffs who were denied employment based on a positive drug test. So the plaintiff in that case appealed to the Third Circuit Court of Appeals. And earlier this year, the Third Circuit Court of Appeals decided that case. So originally, the plaintiff filed a complaint based for himself and everybody else who was denied a job based on a positive drug test. The defendants, after moving the case to federal court, moved to dismiss, stating that CREMA did not provide such a private right of action. So the Third Circuit, in their decision, went through the act. They made several observations about the act, noting that it outlaws discrimination based on a person's use or non-use of cannabis, and that it protects employees from an adverse employment action based solely on a positive test. So that was what Nancy was referencing a little while ago, that you can still test, but you need to determine what to do with a positive test after you have one. The court also noted that the act does not prevent an employer from maintaining a drug-free workplace, which is of huge importance for everyone here today. Does not require an employee to accommodate cannabis use in the workplace, which touches on some of those things Nancy mentioned before about the Americans with Disabilities Act and other statutes that might be invoked by marijuana testing. And it does not amend or affect in any way state law pertaining to employment matters. Now, in making the determination, the court then went on to evaluate a Supreme Court case to determine whether or not a private right of action was allowed based on CREMA in favor of public policy. What the court determined after a review of the act itself, the legislative intent, was that employment protections in the statute did not confer a special benefit on users and non-users of marijuana. There was no evidence of a legislative intent to do so, and implying a private cause of action was inconsistent with the express language of the statute itself. So, having found that there was no private right of action, the court then went on to evaluate the act based on a longstanding case, Pierce versus Ortho Pharmaceutical Group, and they determined that the public policy exception to at-will employment established in the Pierce case was only available to employees, not applicants, and that precluded any claim by the plaintiff in this situation based on Pierce. So what this decision does for the time being is it allows us a viable defense to private lawsuits brought pursuant to the act, and it affirms that it's a previously recognized position in federal and state courts in New Jersey, but it strengthened the fact that Pierce claims do not encompass claims brought by applicants, only by employees. The state courts have not chimed in on this yet. It is possible that they might go a different direction, but for right now, this case is the precedent in New Jersey based on this Third Circuit opinion.
So as we'll see with some of the other information that we're covering, what's going on outside of New Jersey, it's more common, right, for other states, if they're going to have protections for off-work marijuana use, to extend those protections to applicants, not employees. Actually, I think the implication seems to be whatever you did before you were hired, the employer really shouldn't penalize you for, but once you're on board, they can have a rule expecting you not to use. New Jersey is a bit different. And so I guess my question for you, Lauren, is, reading the tea leaves, is the legislature going to amend this? What's the political situation on that right now?
So I have to say, I was a little surprised that the Third Circuit and even the district court ruled on this. In a little bit, we'll be discussing legislation that's going on with Jersey City regarding police officers and marijuana use. And the district court declined to rule, basically saying it belongs in state court. It's really a state court issue. A lot of times they'll certify such a question to the state Supreme Court because it's their law. It was a question of legislative interpretation. So I would not be surprised if we see some sort of litigation going through the state court system or the legislature on its own, trying to close this loophole. But I definitely do think the law is very broad reaching, and it clearly had certain intentions, and New Jersey would not, intend to have a law that had no, enforcement mechanism. So I don't expect this to really stay as it is for a while. An interesting thing, side note, is I was handling a charge with the New Jersey Division on Civil Rights regarding an applicant and medical marijuana use, which is covered by the New Jersey DCR because it's the New Jersey law against discrimination covers medical marijuana. And they started discussing this statute in New Jersey CREMA, and in any conciliation efforts, we're trying to include enforcement of this law and policies regarding this law, even though I don't think it falls under their purview. So it's interesting. I think that there's some creative work going on to try and find an enforcement mechanism for it until the statute presumably potentially gets amended. But for now, there's a slight reprieve out there.
And to be clear, New Jersey is absolutely fine being more protective of marijuana use than, say, California.
Oh, New Jersey, Nancy hears me say this all the time. New Jersey has been on this kind of like wave of, I think that when Murphy was first inaugurated, like the first time, he said something along the lines of, like, we don't want to be the next California. We're going to have California want to be the next New Jersey or something along those lines. So the state is completely happy being on the forefront of this, completely happy. Being more employee friendly, having stronger protections for marijuana use and things of that nature.
Yeah, it's good to know. I mean, so right now we've got recreational marijuana approved in, if not a majority of states, a majority of heavily populated states. Between us, we get just as many questions about people who've tested positive out of Florida and Texas as anywhere else, but they have nothing. You're not supposed to have it there still. But there's a bunch of states that do have recreational marijuana. The question as to whether they have employee protections, though, is much more narrow. So what you'll see in this slide, and this is just, especially if you've got multi-state operations or you want to just kind of compare and contrast, like, why does my the policy that I found on the internet, right, that I want to use not work here? There are some recreational marijuana employee protections, but as I mentioned earlier, it's Maine, Illinois, Washington, and Nevada, the very, very few others. I mean, New York is very broad, as is it's most similar to New Jersey right now, but Connecticut, for example, you can, if you don't say anything in your policy about marijuana, then off-work marijuana use is protected. But if you put in your policy, we don't permit the use of marijuana, then there is no employee protection in Connecticut. Similarly, if you're in a safety sensitive role, you're not protected in Connecticut. So recreational marijuana, off-duty protections exist in 4 places: Rhode Island, New Jersey, New York, and California. And the California protections do not apply if the individual tests positive for active THC, as for example, on the oral fluid test that I measured earlier. So you truly are kind of out there. What sort of protections have you got, and what sort of steps can you take to make sure people are not working while impaired? Becomes more of a challenge, frankly, for you. I know I talk to Lauren quite often, and Lauren, you talk to Demetrius, but we get calls just about every day from employers who are either in New Jersey or they're outside New Jersey, but they've got somebody in New Jersey, and they're like, well, somebody is the business is concerned because they're smoking marijuana in the parking lot at lunch. What can we do? And we're like, that's not okay. That doesn't qualify as off-work marijuana use. But there's so much confusion that we can't really overemphasize, that education here for yourselves and for your employees is really your friend.
Right. And yes, just to cut off, because I know that one of the biggest questions we always get is about exactly what you just mentioned, the safety sensitive. New Jersey does not have a carve out for safety sensitive positions. We are a very construction heavy state. We still do not have a safety sensitive exemption. It's a little odd, very strong unions around here, but there's no carve out that says if you're going to be in a safety sensitive role, we can now, be a little more strict. So that's just something to keep in mind.
Yeah, it's important to be careful. We talked a little bit about oral fluid testing, but for those of you who are not familiar with it, this is a sort of a recent update. The federal government approved oral fluid testing for federal employees, I want to say December 2020, it might have been 2021. And in concert with that, the US Department of Transportation adopted oral fluid as a viable sample for DOT testing. And a lot of people have, regulated workers who drive primarily, or sometimes work on pipelines or in aviation, those sorts of things. And so those regulations by law had to be amended to permit oral fluid tests. That being said, the oral fluid tests have not yet gone live, if you will, for DOT, because DOT is drafting. It has to approve laboratories that can do it, and they need to approve sufficient. I used to say, well, you need at least 2, but there's such an interest in the oral fluid test that I think they're trying to push the laboratories through the certification process, which Department of Health and Human Services is not particularly speedy on that kind of thing. But once that announcement is made, those oral fluid tests will also be available to those of you who are testing DOT regulated workers. What that maybe tells you is that the science of oral fluid testing is here, and that's sort of whether you are subject to those regulations or not, that won't matter so much. So one of the questions is, what's the federal workplace? People who work for the federal government, right? And so the federal government has its, had a couple of weeks ago, 2 million employees nationwide. They're it may be 1/3 that today, but in any case, they're all, customs officials, for example, carrying weapons. They're all subject to drug testing, and so are many others. People who have access to the old executive office building, which is adjacent to the White House, they've been subject to testing for a long time, more as a security measure. So what happens, though, is those regulations apply to our regulated transportation workers, and transportation workers, there's about 10 million of them in the private sector who are subject to this testing by act of Congress and a law called the Omnibus Transportation Employee Testing Act. So what we're seeing, right, is that's going through. What you may not have seen is just about 2 weeks ago, in mid-January, the US Department of Transportation dropped guidance on how to do oral fluid collections for regulated workplaces. And so, sometimes we have groups on here that are actually, vendors assisting in the collection and testing process. That guidance is now available to train people to make sure they understand how to do the oral fluid test for when DOT goes live here. So check that out if you haven't seen that. That's one of the updates we have there. Let's see. We talked about this. Oh,
And
this was
now we're coming to the
earlier
wire.
one. Huh?
So now we're coming up to the wire, I think, right?
Yeah, I think we are. We had a question about that. So, so the statute says scientifically reliable objective testing, right, such as blood, urine, or saliva, and a physical evaluation in order to determine an employee's state of impairment. I reached out to you, Lauren, to ask, like, well, somebody's advertising, they're doing wire training, but like, was there anything new from the legislature? There's not, right? Like, they've kind of
No,
hooted
it
on
is.
that. You want to jump in and kind of talk about that, and I'll roll the
I was
slide.
just like, it's a little odd. So, so when the law was passed, there was all this language about how we're going to have these workplace impairment recognition experts that Demetrios mentioned before, and that they're going to come out with guidance, that police are going to basically be consulted and they're going to prescribe regulations for how to train people and what to do. None of this has happened. So in the past few years, the only thing that's happened is the commission released like a reasonable suspicion checklist, I guess, like, what you can go through to determine whether someone is impaired. So like the physical assessment of someone. And they have not actually done anything about this wire certification. So there was guidance that came out back at the beginning that said, hey, for now, you can make decisions about impairment without a wire. Here's this form to use. You can do it without a wire, but the wire is going to come. It hasn't. So as Nancy said, we started seeing these emails from organizations that are like, oh, like come out and have wire trademark training. And we checked to make sure we hadn't missed anything, but there's nothing there. I think they're just using, their version of common sense or the form that the government gave out and finding with a very entrepreneurial spirit, I guess,
Right.
teaching people how to use it. But nothing's actually changed. So I know we did get questions about what's going on with that. I have honestly no idea. Nothing seems to be going on with that.
I do think that some sort of training is always helpful. It's just that there's no official training or standard. I mostly see people putting together, for example, reasonable suspicion checklists that are too conservative. And one of the questions earlier was like, what if somebody comes to work smelling of marijuana? And I think, without going back to the question, because we've had a few more come in, it was in a school setting. So I'm going to say, like, okay, school setting, like probably public sector. There's a rule there that affects when you can test people. And school setting, maybe a union. That's also relevant. But just specifically speaking to the what about, when can you test someone? Reasonable suspicion. You generally have to have reason to believe that the individual is currently in violation of your policy. You are not, expected to train people to know that people are stoned and it's probably cocaine. That's not necessary. And so, if you have checklists that encourage people to check what's unusual in behavior or appearance, or in fact, the odor of marijuana, and then make a sort of a sensible decision, all things considered, the reasonable suspicion test is not meant to be a gotcha. It's meant to be a follow-up on concerns that you have. And so the New York Department of Labor, which I mentioned earlier, New York has a similar marijuana law. It says something like, the odor of marijuana is not reasonable suspicion. But they put that out, and it's, first of all, nowhere in their statute. I think it's terrible guidance. If someone comes to work every day smelling like marijuana, maybe you have a dress code issue, right? We need you to come to work smelling a little nicer. But if somebody comes to work and they seem just like normal, and then they go for a lunch break and they come back reeking of marijuana, I think that's reasonable suspicion that maybe marijuana got used sometime during the workday, which includes meal and break periods. And you can spell that out in your policy if you don't already. So I don't slam the door on like, oh, the odor of marijuana is simply not enough to move forward. Like, that's silly. You're looking at the holistic thing, and the message to supervisors and employees maybe, we can't explain or understand what we're observing here. Maybe we've asked you, your explanation doesn't make a lot of sense to us because normally you don't smell like marijuana, normally your eyes aren't all red like this. We'd like to ask you for a test now to help explain the situation. If the person tests negative, great, right? Like, it's fine. But if they test positive, we don't have to put our heads in the sand. My little so
Right. And I'll just say, like, I try to treat it, it's similar to alcohol use, right? Like off duty is fine, but not at work. And the trouble is the smoke stays on you, the smell stays if you're smoking. And, if an employee says, oh, I woke up this morning, exactly, I don't have super hygiene, but I grabbed the flannel shirt I wore yesterday and threw it on top of my t-shirt and came to work. You need to have other evidence other than just that smell. And I agree. I mean, I had a call once, Nancy will remember, I called her because I was like, I just got a call from someone that literally someone came out of a restroom at work with like a billow of smoke and smelled. And the client called me and was like, can we test them? And I was like, you can fire them. Like, that's just never going to be okay. Like, even if it wasn't even marijuana, even if it was cigarettes, like, it's a no smoking, like, no, people can't be, hot pots in your bathroom.
in the bathroom.
So part of this is also common sense. We got a question about whether the CRC had interim guidance. They did, but the interim guidance was use this reasonable suspicion and observational behavior checklist.
Yeah.
For the physical evaluation or assessment portion.
Yeah, they kind of sent you back to what you were doing before. It was not very helpful, I felt. We were very disappointed because, as you can imagine, given that we do this, we were eager for something to share with you that would be a little more helpful. I wanted to just jump quickly to the other methods of screening for THC. Because we get asked about this, California's legislature talked about the active presence of THC in an individual's bodily fluids, and everybody I've talked to in California that's testing for marijuana is using the oral fluid test now. But the legislature was like, hey, there's alternative tests that include impairment tests, which measure an individual employee against their baseline performance. And I would just like to tell you that as an employment lawyer, that statement gives me the hives. I don't know what those tests are measuring. They sound like medical exams. I don't know that they've been validated. I don't know that they don't discriminate against people with, sort of a neuroatypical behaviors or processing delays versus everybody else. I know it's their baseline performance, but if you are approached by somebody who says that they can, have developed an impairment test, my advice is to do what you can to ensure that that test has been properly validated and that they will indemnify you in court if you just decide to use it, that it is not an illegal medical exam. A little bit of that. So what is the impairment test? Maybe somebody said, well, it's an iPad and they do like a maze, and like in the days that they're slow at the maze, they get sent home for the day. And I just thought, that's not going to lead to any problems. So there are none in broad circulation or that are validated as reliable that we know of. We also know there's a huge amount of interest in this, and I think people are doing good work. That just because I don't know about them doesn't mean they don't exist, but I think that is something to be aware of if somebody's trying to market you an impairment test. We don't have impairment tests for alcohol, right? The picture here, we have the roadside sobriety test to see if somebody might be exhibiting signs of impairment. Could be caused by other things, other medical concerns. If you're on the road, maybe that it doesn't matter, right? Whatever it is you shouldn't be on the road. At work, and it's a little bit different. Alcohol tests measure the amount of alcohol in your system. They do not measure impairment. It's just we've got decades of data saying with this amount of alcohol in your system, you are likely to have the following impairments. We have that. I think I've been on my soapbox long enough for that. Oh yeah, we're going to talk about gun rights and marijuana. The federal firearms law says you can't have a gun and use illegal drugs, which includes marijuana at this point, but the laws are being challenged. Demetrios or Lauren, I think Lauren, were you the one who said you were going to talk about the case out of Jersey City?
Right. So federal law prohibits, use of or possessing a firearm or having a firearm and using marijuana. But luckily, New Jersey does not think that I guess we are covered by federal laws at the moment, so we're just going with it. So there's been an ongoing battle, which many of you may have heard of, where in Jersey City, 5 police officers tested positive for marijuana and were terminated. They sued to be reinstated. And then separately, Jersey City filed a lawsuit in the District Court of New Jersey to try and say that provisions of PREMA were unlawful and preempted by the federal firearms laws. So as of right now, New Jersey state courts have taken the position that you cannot be terminated. They do not think it necessarily prohibits you from having a weapon. Last I heard from my digging around, the people were reinstated to work, but they are on desk duty so that they do not have a weapon, because Jersey City didn't think that was a super idea. But the federal government, the federal courts have declined to rule on this or take any action. And basically something along the lines of, if the federal government thinks that what we're doing is wrong, they can come down here and do something about it. So I guess as of now, it's kind of a stalemate of what's going on, but that just kind of shows. So even armed police officers in Jersey City who are required to meet federal standards to have a firearm are not allowed to be terminated because they test positive for marijuana. And this has kind of been my, Nancy hears me, like, this is kind of my throw out there like story, because we always get a lot of questions like, well, what about a teacher? What about this? And I'm like, we are apparently okay with armed police officers running around one of our busiest cities and testing positive for marijuana. So I think that really sets the tone for how they feel about, you know, drug testing currently, especially metabolites, and not using oral fluids. So, you know, we'll wait and see how that develops, if at all, but
yeah, I mean, I don't know anything about the police union in Jersey City, but I often see union contracts that talk about drug testing, and like urine testing is like in the CBA, and I'm like, why, right? Because like the union should want the testing to only focus on whether the person is impaired and the shorter detection window. But you know, there are time frames for these things. The CBA is good until it's renegotiated. So something to think about if you want to shift to the more updated testing. It's probably good for everyone. Your union might be welcoming of that, or they might not. But I, you know, keep coming back to like a little bit of, you know, a little bit of labor law there. Like you may have your hands tied for that a little bit, and have to, you know, work with them on getting that done. I'm going to talk a little bit about opioid abuse updates. There's a little bit of good news. We don't have the final numbers for 2024. They're in the high 90,000s, but it looks like opioid deaths have gone down this year. And particularly in New Jersey, this organization has been doing a lot of good work there. We're seeing less come into the country. Lauren, I think you did some statistical research on why the reasons for that might be, besides that naloxone or Narcan is now widely available where it wasn't before.
Well, so we were all discussing before the call, you know, drugs are being a little less strong because, you know, the people who are selling them and bring them into the country want to make sure that people live long enough to continue using them. So I guess business people are getting smart. Business.
Some of the cartels. And so we have had a significant drop in the number of overdose deaths.
Yeah, sorry, I was looking for the New Jersey number, so I apologize. But
I only saw some preliminary numbers. Did you say?
Yes, we're expecting a 30% decrease.
That's fantastic.
In New Jersey. For overdose deaths. And so that's a great statistic. And I know, you know, partnership has been involved in that. So that's great work. Definitely, you know, the result of prevention, education, and treatment also.
You know, the numbers of overdose deaths, one of the states with the highest number of overdose deaths was Ohio, and their numbers have come down this year. And one of my college roommates is a physician in Ohio, and they have Narcan in vending machines at her medical office, and it's free. You just ask for one and you get a Narcan kit. And so anyway, if you have there are protections against employers that administer Narcan. If you don't know this, it's an opioid agonist, meaning it only kind of counteracts the effects of opioids. Especially, it's available in a nasal spray. You don't have to give somebody a needle. It doesn't do a darn thing if the person is, not having an opioid overdose. So if they're in diabetic attack, coma or whatever. So if you see someone who's distressed, you should call 911. That should be your number one go-to thing to do. But if you have Narcan on site, there is a Good Samaritan law that it protects people, who administer that against any claims that they harm someone. If the person said, "Oh, I was trying to kill myself," what were you doing? But in general, it's a very safe drug, which is why they made it available over the counter.
And it does impact drug test results. Is that correct, Nancy? I know you've had some
Oh.
situations with this one.
Oh, yeah, I have had a few situations with this one. It's not the Narcan doesn't impact drug test results. It's just that none of you are all attentive for fentanyl. Fentanyl's not.
That's what it was. Okay.
It's not on your standard drug testing panel unless you go out of your way to add that. And some employers have, but it's not the standard 5-panel test. And so you may not know that people are using. You'll probably see if they're using it at work. They look very impaired, but very, very sleepy indeed, for example. But that's something.
That's what it was. Sorry.
Yeah, no, it's a good point. It's a good point. There is a lot of information on the OSHA website, this is NIOSH, which is the research arm of the Occupational Safety and Health Administration outreach, and there is a lot of information on opioids and Narcan, and you can learn all about it, and it's totally available. We also are coming up close to the end here, and I think we've maybe answered most of the questions, but I wanted to talk a little bit about the Recovery Friendly Workplace, which is an initiative that was started in New Hampshire, where employers provide a lot of support for people who have had addictions in the past. And I mean, obviously, a great initiative. I've done presentations specifically on how to work with people who are drug users or abusers, whether they're in recovery or not, because we have so many, 48 million people used marijuana last year. It's more than people who drink alcohol. And the younger generation seems to think that it is safer. I don't know what's up on the government website right now, but in September 2024, federal government released a report saying the risks of marijuana use have been really downplayed. Like, people went from thinking it was super dangerous and we hyped that up. It was super dangerous. It's illegal. You shouldn't use it. And then once we legalized it, people were like, it's great. It'll solve, all of your problems. I even saw one advertisement saying that it could cure ALS, which, by the way, if I thought that was true, that would be amazing, but I don't believe it to be true. But there's a lot of people who are, using concentrated marijuana, vapes, THC. I just learned yesterday that it's actually associated with congestive heart failure and hardening of the arteries, like high blood pressure. I was like, what? But we have a lot of people with marijuana hyperemesis syndrome, where there's constant vomiting, and it's associated with mood disorders and a bunch of other things. So you're going to have people who have drug issues, whether it's marijuana, which we think of correctly or not as a soft drug, up through, fentanyl, and they're going to be at work, and hopefully they're not using it at work, but they may need your support if they've had issues in the past. There's a lot of resources available. This is from Department of Labor website. Again, a lot of things have changed in the last couple of weeks about what's available on government websites, but you can also go and look at various state recovery-friendly workplace initiatives. My suggestion to you is, if you want to sponsor a recovery-friendly workplace, that you look at their suggestions and consider what you can do and what might work for you. Some of the policies talk about, like, let's ask people to share their stories on addiction. Okay. Some of it's more like supervisors should ask people if they are in recovery. And that, for me, again, as an employment lawyer, is like an absolute do not do that. You will be hit with a lawsuit if you ask. Do not, maybe not by that individual, but asking about people's medical information is dangerous. And so if you want to put together a recovery ready workplace, take a look at that, and then, run it by your HR department and your counsel to make sure you're doing it right. Greg, I see a poll on our screen. Do you want to talk about that, or is that coming up next?
Sure, I'll handle that in just a few moments here. But Nancy and Lauren and Demetrios, well, we want to thank you so much for giving us a very comprehensive presentation and showing us what is going on and also what employers need to be doing. So thank you very much. We will get to a few questions here in just a moment, but you did mention the poll there. I just wanted to make sure that folks take the few moments to go ahead and address that poll. It'll popped up on your screen a few moments ago. We encourage everyone who is attending today to please fill out that poll, and we'd be most appreciative of that there. Just for a few questions, if we could, why don't we start with this question? Has there been an increase of drivers arrested for being under the influence of marijuana since adult use of marijuana became legal? Who would like to weigh in on that question?
I,
Yeah.
I actually, I don't, has there been an increase, you said, or has there been a decrease?
Increase of drivers arrested.
Oh, drivers. So
Yep.
no, it doesn't appear to be, but part of that is because the statistics don't track. People get arrested for a DUI. It doesn't track whether it's for marijuana, whether it's for anything. But the numbers have stayed mostly level. One of the big things am kind of, I don't want to say looking forward to, but one of the things is, as Nancy just said, studies are coming out now about possible harmful effects of using marijuana. With marijuana being unlawful, there were studies were limited, and ways of testing are limited, everything, there wasn't a lot of money being put into this. So now with the oral fluid testing becoming more prevalent and accepted, I would expect New Jersey and other states to adopt, a standard, a testing, level similar to the blood alcohol content that would enable people or police officers to, test someone. But as of right now, if someone's pulled over for suspected impairment for anything other than alcohol, the only recourse is the field sobriety test, which is pretty much, it's hard to prove that beyond a reasonable doubt that someone's impaired without some sort of scientific test to.
Yeah, I would say nationwide, the numbers are definitely up, and Colorado track that. I will warn everybody, because you're on a border with Pennsylvania, they do have a per se impairment if you've got, marijuana on an oral fluid test that they do. So I think that those are going to be.
New Jersey is not doing oral fluid testing.
No.
Yeah.
No. But
so that's the thing. So I expect that if the police start using oral fluid testing, we will see a very, very high, a big spike. But nothing yet.
There was a bill introduced in the new, in the New Jersey legislature about a year ago to allow officers to require blood sample testing if someone was suspected of driving high, but there hasn't been much update on it. So it seems like it's either stuck in, legislative limbo or was very unpopular, but there is a legislative push to do something to get further testing on impaired drivers.
Great. Another question, if I could, for our panelists. There was an employer who asked a question about other drugs that are out there. Psilocybin, ketamine, the drug that actor Matthew Perry abused and died as a result of an overdose. What can you tell us as far as any of these drugs becoming legal for adult use? And should we be educating our employees about these drugs and other drugs that are out there? And do you have any suggestions for employers on this topic?
So for education, I love it. There's always a lot of information over at the National Institute on Drug Abuse. They do like fact sheets that are very helpful on that. For psilocybin, you're hearing it in the news a lot lately. That's magic mushrooms for those of you who are unfamiliar. It has been pioneered for the medical use in some very troubling sort of I'll call them mental health issues. However, I don't know, there was an effort to legalize it, and a lot of cities out west kind of did that, but Massachusetts had it up for on the ballot this year. All of the state ballots to either legalize marijuana or to legalize psilocybin, Massachusetts being the biggest this year, were defeated at the ballot box this year. So I don't know if we've come to the end of the thing there, but yeah, I don't know that it's going to come anytime soon. You're not going to be able to test for it. It's sort of in and out of somebody's system. They're sort of profoundly impaired for a very short time. Ketamine is getting a lot of buzz because it's apparently a well-known billionaire uses it medically with doctor's supervision, but That's also a little bit like propofol. It's an anesthesia. I haven't seen it coming up in the workplace yet, but we're always looking for new highs.
Anything you'd like to contribute in terms of, and it was one of the items that came up here in our webinar chat about encouraging employers to become recovery-friendly workplaces, and we may have touched on this a little bit. Would you be able just to define the term for us once again and provide some examples that employers can do for employees and maybe in long-term recovery, and why this makes sense from both the legal and economic perspectives? Can anyone just comment on that briefly?
Well, I think, getting rid of employees just because they've had a drug problem in the past or not giving them a second chance. Many employers have realized that that's not where they want to be, and that a lot of people have engaged in drug use. Some people were prescribed medications and then became dependent on them. A little bit less blame, a little bit more support. Setting aside, you're not working in a nuclear power plant. There are places and situations where a zero tolerance policy is still appropriate, but it is kind of gathering employers and giving them education about how to support employees in this, and to encourage employees to sort of stay drug free and be successful. And Bill Lillis put in, I think, the chat that there was a blog post from the person who's running the New Jersey recovery-free workplace recently. I'd go ahead and take a look at that. But my advice was, it's a great thing. Just be careful about implementation, because you don't want to go too far and be perceived as intruding on someone's medical life.
Sure. Well, our panelists, thank you. You did a great job of sort of going on the fly and addressing the questions that popped up in the live chat there. So thank you for that. We're just clear of the 12 noon hour here, so we're going to bring things to an end in just a few moments. So we want to give our panelists a minute just to offer their final thoughts on the subjects that we covered for today. So Lauren, would you like to go first with that?
Sure. So we got into our discussion. So we didn't get to the very last slides, which is my area, my favorite potentially, is about policies. So just remember, you're allowed to have policies, you're allowed to have things. And most importantly, my practical, thoughts on all of this, which we hit on briefly during the presentation. There's a lot of focus on drug testing, when you can test, when you can't test, when you can use the test results, when you can take action against people. It's very important for employers to keep in mind, a lot of this will result in performance issues and in other things that you can manage and discipline without having to do a drug test or even go down this route. And so that's kind of my big, overall advice to people is always don't corner yourself in or box yourself in with thinking that someone might be using marijuana. Why do you think they're using marijuana? Do you think they're using drugs or something because they're always late, because they're always this, because they caused a horrible accident? There's a lot that will cause someone to, have quote unquote reasonable suspicion or think that, there's impairment at work. And if there's impairment, not just, the suspicion that, someone smells, but like if there's signs of impairment, there's likely other things you can do and steps you can take without the drug test anyway.
Excellent. Thank you very much for that, Lauren. Nancy, some concluding remarks from you today?
Well, we covered so much, but I would just add to Lauren's point, like it is illegal in every state in the union to operate a motor vehicle if you've got active THC in your system. And so whether you're likely to be pulled over by the cops or not, if you're an employer and you're putting people behind the wheel and that you know that they're using marijuana, you might want to take steps to minimize your potential liability for negligence, get those oral fluid tests in place. If you're outside New Jersey, don't let them occupy those safety sensitive roles at all. So that'd be my big takeaway. And it's good for, anyone who's a recreational or medical marijuana user as a reminder. It's still, there's every single medical marijuana law, every single state recreational marijuana law says, except that you shall not drive a vehicle while you've got marijuana in your system. So take care of yourselves and everybody else.
Well, Nancy, thank you as always for your information that you contribute to this. And lastly, Demetrios, great to have you actively participating with us today as well. Any final thoughts that maybe you want to add on from Lauren and Nancy today before we wrap up?
Yeah, so I want to piggyback off what Lauren said. You can do the testing at work when you have a suspicion that somebody is under the influence at work. The State Regulatory Commission has not done us any favors in the wire criteria, but the form that they did put out with their interim guidance is helpful. It lists 21 specific physical attributes that you should look for, and there's probably closer to 30 behavioral things that you can look for as well. Document if you have the suspicion. Do it with multiple people. Don't have just one person saying they observe these things. Have a manager, the other supervisory officials fill out the form. If this comes back to you for a termination or for an employment action, you want your documentation to be, you want it to be there. And as the employer in New Jersey, because of the way things go in the state courts and with other various state agencies, you need to be perfect. So you want that documentation to back up what you saw, because it's the only record that you're going to have to show what the situation was on the day you made your determination.
That's a good point.
Thank you once again to all of our speakers, and we very much appreciate that you could give this presentation today. We know these are challenging times, obviously, for employers when it comes to handling marijuana in the workplace and other issues. But I think your presentation really provided employers here in New Jersey with a very good sense of where things are and what steps they can take to maintain a healthy and safe and drug-free workplace. So thank you so much. The Partnership for Drug-Free New Jersey will continue to monitor any new developments on this issue, and of course, we will keep our members fully up to date. Our recording of the webinar and the slides presentation will be sent to all who have participated. And if you'd like to receive a certificate of participation, please respond to the email when you receive the slide presentation. Once again, thanks to all of you who attended the program, and on behalf of the Partnership for Drug-Free New Jersey, we wish you the best as you move forward on this most challenging issue. Thank you, have a good day, and thank you for joining us today.